That job application you just watched someone fill out, it didn't have the criminal history question on it. Not because the employer doesn't care about your record, but because the law in that city or state says they can't ask about it yet. That's what ban-the-box laws do. They don't eliminate background checks. They delay when employers can ask about your criminal history, pushing that conversation to later in the process, after your qualifications have already been evaluated. In those jurisdictions, you get to be seen as a qualified candidate before your record becomes the focus. And that timing change makes a measurable difference in hiring outcomes for people with records. This video explains what ban-the-box laws are, where they apply, how to use them strategically, and what to do if your rights are violated. This is Felon-Friendly Jobs Now. Let's get into it. The term ban the box refers to removing the criminal history checkbox from initial job application forms. The name comes from the literal checkbox that historically appeared on virtually every employment application, asking whether the applicant had ever been convicted of a crime. The policy concept is straightforward. Evaluate applicants on their qualifications first. Consider criminal history later in the process, typically after an interview or after a conditional offer, when the employer has already determined that you can do the job. Research on ban-the-box policies has consistently found that they increase callback rates and interview opportunities for applicants with criminal records. Getting in the door to make your case in person changes outcomes in ways that being filtered out by an automated checkbox does not. The terms ban the box, fair chance hiring, and second chance hiring are often used interchangeably. They all describe variations of the same core idea. Give qualified applicants with records the chance to be evaluated on their merits before the record becomes the deciding factor. As of 2026, ban-the-box or fair chance hiring laws apply in a significant and growing portion of the country. Here's the breakdown. For public employment, government jobs, ban-the-box policies apply in 37 states and the District of Columbia. If you're applying for a state or local government position in most of the country, the employer generally cannot ask about your criminal history on the initial application. For private sector employers, the ones most people are applying to laws restricting criminal history questions on initial applications apply in 15 states and the District of Columbia, as well as in more than 150 cities and counties. At the federal level, the Fair Chance to Compete for Jobs Act took effect in 2022. This law restricts federal agencies and federal contractors from asking about criminal history before making a conditional offer for most covered positions. If you are applying for a federal job or a position with a federal contractor, this law may apply to you. Some of the strongest local protections are in New York City, Los Angeles, San Francisco, Seattle, Chicago, Newark, Philadelphia, Washington, D.C., and Minneapolis. If you are in a major metro area, check your city's specific ordinance. Local laws in these cities often go beyond what the state requires. In jurisdictions with private sector fair chance hiring laws, the standard framework works like this. Employers cannot ask about criminal history on the initial application form. They may ask later, often only after a conditional job offer has been made. Before making an adverse employment decision based on criminal history, covered employers in many jurisdictions must conduct an individualized assessment. Individualized assessment means the employer must consider the nature and gravity of the offense, the time that has passed since the offense, and the nature of the job, and whether the offense is directly relevant to its duties. They can't just see a conviction and say no. They have to actually evaluate whether it's relevant. In some jurisdictions, employers must provide written notice of the reason for any adverse decision based on criminal history, and give the applicant an opportunity to respond before the decision is finalized. That opportunity to respond, to provide context, to submit a reference, to explain what has changed is significant. Knowing your jurisdiction's rules changes how you should approach applications. Here is how to use this information strategically. First, know whether your city and state have ban-the-box protections and what they cover. A quick search for your city or state name plus ban-the-box law will usually get you there. Your state's Department of Labor website and legal aid organizations are authoritative sources. Second, if you're in a ban-the-box jurisdiction and an employer's initial application asks about criminal history, that question may violate local law. You have options. You can note the question and choose not to answer it at the initial stage, explaining that you'll address it later in the process, per the applicable ordinance. Or you can contact the employer's HR department before applying to clarify their process. Third, in any jurisdiction, deliberately targeting employers who have publicly committed to fair chance hiring is strategic. Many large employers have voluntarily adopted fair chance hiring policies beyond what local law requires. The FFJN Employer Directory identifies companies with these commitments. Use it. Fourth, if you receive an adverse action notice after a conditional offer, use the response opportunity that some jurisdictions require. Write a brief professional letter. Acknowledge the conviction. Describe what has changed. Provide references. Request reconsideration. That response window is a legal protection. Use it. Let's be clear about what ban-the-box laws do not do, because understanding the limits is as important as understanding the protections. Ban-the-box laws delay the criminal history inquiry. They do not eliminate it. Employers can still run background checks, typically after a conditional offer. They can still consider relevant criminal history. What the laws do is ensure your qualifications are evaluated first, and that the criminal history review is more structured and accountable. Ban-the-box protections also don't apply in all circumstances. Jobs with security requirements, positions working with children or vulnerable populations, and many licensed professions have separate legal frameworks that may override fair chance protections. Know the specific rules for the type of job you're pursuing, and ban-the-box laws only apply where they've been enacted. If you're applying in a jurisdiction without these protections, the initial application question is legal, and you need to answer it honestly. If you believe an employer in a ban-the-box jurisdiction violated the applicable law by asking about your criminal history, at an improper stage of the process, you can file a complaint. At the local level, complaints are typically filed with the city's Office of Civil Rights, Human Rights Commission, or Department of Labor, whichever agency enforces the local ordinance. At the state level, the State Department of Labor, or Civil Rights Enforcement Agency, typically handles complaints. Document what happened before you file. Write down the name of the employer, the position you applied for, the date of the application, what question was asked, and at what stage of the process. Screenshot or print the application if possible. These records support your complaint. You don't need an attorney to file a complaint with an enforcement agency. The process is designed to be accessible, and filing a complaint, even if the outcome is uncertain, creates a record and contributes to enforcement of protections that benefit everyone in similar situations. Ban-the-box laws exist because employers and policymakers recognized something that research confirmed. When people with records get the chance to be evaluated on their qualifications first, more of them get hired, and more of them succeed in those jobs. These laws are not charity. They are a corrective to a hiring process that was filtering out qualified people based on a checkbox before anyone ever read their resume. If you are in a jurisdiction with these protections, use them. Apply with confidence. Get your qualifications in front of a decision maker before the record becomes the conversation. That window between application and background check is where you make your case. Know when it's open. Visit felonfriendlyjobsnow.com for our Fair Chance Employer Directory, state-by-state ban-the-box law guides, and interview resources. All free. Link in the description. Before your next application, know whether your city or state has ban-the-box protections. Know what the employer can ask and when. Know your rights if they ask at the wrong stage. That knowledge is leverage, and leverage changes outcomes. They can't ask yet. Use that window. Make your case. Get in the room. Subscribe to Felon Friendly Jobs now for legal rights and re-entry strategy every week. Drop your city in the comments. Ban-the-box coverage is local, and we want to know where you are. I'm rooting for you. Know your rights. Go apply.